My lady, my lords, I'll soon be out of your hair, such as it is. Can I just come back to one or two things? My Lord Justice, risk. In the Australian case of Marriott, Justice Jaddo, this is Justice Jaddo, affirmed by the Federal Court, she said the following. Perhaps I could, I don't know whether you really want to look it up, but it's in Authorities Bundle divided 84 at paragraph. Which is on page 2015. In cases it happens. Whilst you're looking, can I just tell my lady that following the practice direction in the order in which the and so I rise to that in saying that and particularly meant bundles were in the appearance that your ladyship saw.
Which is why I observed that perhaps we needed to revise the practice direction, Mr. Keeley.
That's very kind. At paragraph 84, it will also become apparent that there is an important distinction to be drawn between insuring provisions which depend on the occurrence or outbreak of infectious or contagious disease within an area, and insuring provisions which depend upon the threat or risk of an occurrence or outbreak of infectious or contagious disease within an area. The two concepts are different. Care must be taken on the line between them. And then her ladyship went on to say, where the geographical area is a large relative number of cases, or there is a difference between the government actions were taken the actual outbreak or occurrence within a specified area, and assessing whether the government actions were taken in response to the threat or risk of the spread of COVID-19 across a wide area, such as a state. So that's the first point I wanted to cover, arising out of this. The point that her ladyship put much better than I explained this morning. And turning to a point raised by my lady about everywhere, could I just remind you what the division said in FCA, which is Authorities Bundle 1, Authorities, well, it says Divided. And it's at page 76, and it's in the right-hand column. There's a passage in paragraph 405, which was a discussion about the meaning of incident and whether it is the same as an emergency or a danger. And about a third of the way down by the first hole punch on in the right-hand column, you'll see a reference to Mr. Kaizen, where he says a state of affairs. Then we consider that Mr. Kaizen QC's analysis is correct. Saying that the pandemic is everywhere does not mean that it is present at particular insured premises, and then goes on with the 1 mile radius of it. And that was the point again that I was trying to make this morning. Saying that it's everywhere doesn't actually help you in determining whether or not it is at a particular location. And really, there are three categories. It's perhaps there are two, but I'm going to merge them in a second. There are three categories. If there is merely the risk of disease somewhere, which is why you close a premises down, that is not covered. The coverage is for an occurrence or outbreak of disease at a premises. All there is the risk in the future there might be. On the other hand, if it is known, for example, because a swab has been taken, scientific investigation has been undertaken, simply because of medical evidence, if it's known that there is a disease at a premises and it is closed down, well, that's a known case of disease at the premises. Well, there's a case which might be said to be in the middle, but actually we think it comes within the latter category. If there is a belief that there is a case at the premises, and the person who has that belief forms the view that there is disease at a premises, and that view turns out to be correct, then that is the equivalent of a known case. That is a covered case, because the reason why action was taken vis-à-vis those premises is the view that there is disease, the belief there is disease at those premises, which turns out to be correct.
You referred this morning to a reasonable belief.
Yes.
Your formulation then was simply a belief.
No,
Any distinction there?
I didn't mean to. On this occasion, I'm just talking about the categories that one can identify. If you look at the Royal Insurance case of Mr. Justice Roberts, where it discusses what knowledge philosophically normally means, he associates a belief based on reasonable grounds as being the equivalent for insurance purposes of knowledge. So if there is this shop in Upper Street that is closed because it is believed to contain disease, reasonably believed, it's not just an arbitrary belief, just pure speculation, but it's believed on reasonable grounds. For example, viruses have been seen in the locality emanating from the place, coming out, if you can see them, which you can't, then that is good enough. And that means that that is covered.
Yes. So your point then is reasonable belief is the relevant.
It is.
Yeah.
And it turns out to be true.
Of course.
Yes. And that is actually the case that we made below as well. This doesn't differ from what I said before. I think it's been held against me that I was talking about belief, but I actually think that the criticism is misplaced. Is whether the premises are being closed down because of an occurrence of COVID there. Believe there's COVID there, so you close the premises down, it turns out your belief is right. Then I think a normal person would say, well, it's been closed because of an occurrence or the presence of disease at the premises. Now, I'm going to turn back, if I may, only briefly, to FCA, and then I'm going to close down, as it were. So if we can go back to FCA, which is divided to authority, I think we've got essentially up to paragraph 194. And the reason why it's important to see what they were discussing in 194 is because they were concerned with the but-for and the weighing arguments that were being advanced by the insurers in that case. If you look at paragraph 195, against the background of 194, the learned judges say we don't consider it reasonable to attribute to the parties an intention in such circumstances, the question whether business interruption losses were caused by cases of a notifiable disease occurring within the radius is to be answered by asking whether and to what extent, but for those cases of disease, business interruption loss would have been suffered as a result of cases of disease occurring outside the radius. Not only would, this is an analysis of the applicability and validity of the but-for test. In other words, but for the cases in the radius, would the interruption still have occurred? In other words, irrespective of the cases in the radius, would the interruption losses have occurred? Can the insured, it was said, prove the factual causation test of but-for? Because if they couldn't prove it, if those business interruption losses, if those closures would have taken place in any event, irrespective or but for the cases in the radius, insurers were arguing, well, that's not covered. And the Supreme Court went on. Not only would this potentially give rise to intractable counterfactual questions, but more fundamentally, it seems to us contrary to the commercial intent of the clause to treat uninsured cases of a notifiable disease occurring outside the territorial scope of the cover as depriving the policyholder of an indemnity in respect of interruption also caused by cases of disease which the policy is expressed to cover. We agree with the FCA's central argument in relation to the radius provisions. The parties could not reasonably suppose to have intended that cases of disease outside the radius could be set up as a countervailing cause which displaces the causal impact of the disease inside the radius. In other words, if it's the case that cases outside the radius would have caused the interruption irrespective of the cases inside the radius, it is being said that that is contrary to the commercial intent of the parties, because it would be treating the cases outside and the existence and causal impact of the cases outside as being in effect an exclusion clause applying to deprive the insured of cover. That's what the court was concerned with. It wasn't concerned with anything like my arguments, because those arguments are inapposite to a radius clause. When the court there also says that it gives rise to intractable counterfactual questions, well, that's because what you've got, and that covers also the weighting point, that's because it's very difficult in cases where you have disease within a radius, which could be as much as 25 miles. It could be London. Very difficult to work out how the government would have responded were it not for the cases outside or inside the radius, whichever way you're looking at it. Whereas in our case, we say that actually the counterfactual, it's not really a counterfactual at all. It is an interpretation of the facts as to what caused the premises to be closed down. Was the local authority closing down, or the governmental authority closing down the premises because of the presence of disease there, or not? In fact, in most cases, in the huge majority of cases, because those are the cases which most frequently happen, that wouldn't be a problem at all. And of course, problems of proof should not really defeat a properly constructed causal analysis, if the causal analysis is justified by the policy wording. It's rather like saying business interruption losses are extremely complicated to quantify and very, very difficult. So what? That's what the parties agree, and that's the normal things. That's a normal thing that policyholders and insurers have to deal with business interruption losses. So in summary, a radial peril describes the premises being closed by reason of disease in circumstances where the order for closure is highly likely not to be dependent on the presence of disease within the radius at all. In these circumstances, one could not require the cases within the radius to be a but-for cause of the closure, because to do so would be to render the cover illusory. It would produce the result of the clause not covering that which it is intrinsically designed and contemplated to cover. And that's what the Supreme Court decided in FCA.
I'm not sure why the counterfactual question would be all that intractable in a radius clause. If you take the facts of this case, the answer would be pretty clear, wouldn't it?
On the facts of this case, I suspect that they would. They would.
Perhaps in other circumstances it would be more difficult.
I think it is. It all depends on the circumstances. In the FCA case, they were looking at particular radii with respect to particular insureds. I mean, not particular insureds, because the FCA was acting for all insureds, but on a national basis, where you have a radii of 1 mile, of 25 miles, then it may be difficult to work out what is going on. Within that, the premises clause, in my submission, and I'm not an expert on this, but this is just common sense, you can tell whether a premises is closed because of that which occurs on the premises, I took you to the relevant legislation in relation to vermin and pests and things like that. In relation to disease, it shouldn't be difficult at all. Indeed, in our case, where we are saying that a blanket closure by a national government applied nationally without reference to anything that goes on in any particular premises is an easy case. You're not talking about any counterfactuals or working out whether the premises were closed because of that which occurred at the premises, because you're not. Now, if, as I said earlier, if they closed down Cheltenham, say during the Cheltenham Festival, because they could see the punters rolling out full of COVID, and they closed that down, then you would know about it. And Cheltenham is not a bad example, because here we got the London International Exhibition Centre, which is a big premises. My own friend made much of it, the fact that it's so large. I actually think it works against him, but that's beside the point. It's so large. I mean, you would know if the XL Centre is being closed down because of disease at the centre. The judge, I'm not going to criticise the judge too much because my criticisms are already in the skeleton arguments. But the judge reasoned in the judgment, which is Core Bundle Divider 28, page 423, paragraphs 203 to 5. If you look at 203, it's a point that was raised this morning, but essentially what the judge was saying is that the insured peril is simply about the geographical scope of the coverage. He said, essentially, because the Supreme Court's analysis can apply to a 1-mile radius just as much as a 25-mile radius, there is no reason why it can't be further shrunk to the premises themselves or itself. That's what he says in paragraph 203. But with the greatest respect, that simply misunderstands the analysis of the Supreme Court. The size of the radius is something to do, in the case of a 1-mile or 25-mile radius, with the character that the policy recognises of the governmental response. It will be a response as much to do with the cases within the radius as outwith the radius, and it will therefore necessarily be a wide area response. It's not a question of just shrinking the radius. The scope and meaning of the peril is directly relevant, according to the Supreme Court, we agree, when ascertaining the important requirements that apply to that peril. And the geographical scope of the radial peril, by referring to external and not internal disease, was critical in dictating that wide area interventions were necessarily covered. Now, I don't want you to think that the Supreme Court decision was not unusual. It was unusual. But it's important to understand what was unusual about it. There was nothing particularly exceptional about the idea that one can have multiple concurrent proximate causes of approximately equal efficacy. And that if one cause is covered, then the policy may have to respond. But if one of those causes is excluded and they are interdependent, then the policy doesn't respond. The FCA case seems to be the first case, however, to have decided that a concurrent cause can be a proximate cause in the contractual policy area, even if it's neither necessary nor sufficient. In other words, you can have a combination of non-necessary and non-sufficient causes, the aggregate of which result in the action by the government. And there's no conceptual reason why that is not possible. What was unusual about the FCA Supreme Court, and this is really all that was hugely unreasonable, was that one occurrence, or an occurrence, which conceivably made an infinitesimally small causal contribution to the loss, could nevertheless qualify as a proximate cause of that loss. But there wasn't particularly novel legal reasoning. The basic principle at play was proximate cause. The result reached was unusual because it's highly unusual in practice for parties to intend that an infinitesimally small contribution cause can amount to a proximate cause. But, and this is important, the conclusion that the parties to a radius clause nevertheless had to be treated as having that intention was the product of the wording, the function, and the purpose of a radial provision. And the conclusion of the Supreme Court, therefore, was highly particular to the radial clauses under consideration. And it's wrong to read them across. Now, our approach does not render the cover illusory, even for spreading contagious diseases. It's a construction that provides valuable cover, including for diseases that to spread widely, while, however, remaining faithful to the language of the clause. So clearly, ATP clauses, this is a matter of paradigms, the ATP clause is intended to cover those disease risks which occur with the greatest frequency, and is not intended to cover those rare, unprecedented, exceptional cases where the occurrence of disease attracts a blanket, generalized authority response. And that, my lords, my lady, is to be preferred to the understanding of proximate causation contended for by the insureds and embraced by the judge, which severs any meaningful link between the occurrence of disease at the premises and the closure of those premises. Now, is that unfair and uncommercial? The fact that the policyholder may not have cover for its losses in the circumstances of this case is no reason for departing from the meaning and causation requirements of the policy. And one only has to look at the words of Lord Mance in China Taiping as being the appropriate apposite epilogue. If one goes to Authorities Bundle, tab 64, one goes to page 1574, paragraphs 103 to 105. This is in relation to the conclusion that His Lordship came to, which is competent local authority means competent local authority and does not extend to the central government, even if the central government has competence to act locally. And His Lordship said, as to these factors and uncommerciality in particular, even in negotiated contracts, one must be alive to the possibility that one side may have agreed to something which, with hindsight, didn't serve his interests. Now, just pausing there, at the time when this policy was concluded, I'm sure both policyholder and insured, looking at the ATP clause and thinking that it meant what I say it meant, thought it did serve their interests, because they didn't contemplate a pandemic. Lord Neuberger, commercial common sense is not to be invoked retrospectively. The mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously for one of the parties is not a reason for departing from the natural language. The COVID-19 pandemic has been a sad disaster for many, including, as I appreciate, very probably many of the present policyholders. but it would seem unfair and inaccurate to suggest that if the insurer's case is accepted, the present policy will have worked out badly, still disastrously for the policyholders. I doubt whether it was actually entered into with any specific thought to, or to the insurance position, in relation to a national pandemic. And that's what we say is an apposite epilogue to my submissions. And I leave them there, my lords, my lady.
Thank you very much.
My lord, my lady, before getting into the weeds of vermin and kebabs and Islington, I'm going to firstly step back even from this case, just by way of scene setting, as this is the lead case. You'll know that in the coming days you've got 5 appeals on preliminary issues, Pizza Express having settled. Each has slightly different facts and wording. Some have more than one policy within them, but with the same, or essentially the same wording. You know there's the common causation issue. That's what we're spending all of our time on the Excel case, because that's our only issue. And those policies are summarised in the judgment at 72 to 110. You don't need to look at it. And indeed in the Appendix 1. So that judgment, you'll recall the categorisation at Judgment 116 that's also in the test case: disease clauses, hybrid clauses, and POA, prevention of access, or NDDA clauses. All of ours are hybrid clauses other than Hair Lab, which is a pure disease clause, meaning that although the causation question is largely the same, the clause doesn't refer to public authorities at all. It just says disease, interruption, and we've got one connection. There are separate test cases about POA clauses, but we will have to briefly look at the authority of Corbyn and King. And we've already looked at the market demands authority of China typing. Now, the Excel facts I don't need to really deal with in detail. I think you'll have seen the facts about the Excel centre itself. We'll look at the clause in a moment. Just to remind you, in the schedule, which is at CB core bundle 32, unless you've taken it out, at page 547, you'll see it's an RSA wording. And just over leaf, to tell you where we are, you see the insurers listed. RSA, who was the lead, conceded causation at trial and has not appealed. They agreed with us. CNA has settled on confidential terms, so you're left with a dispute between Excel and Allianz, Aviva, Zurich and Chubb, Zurich being the only one who was a party to the test case. So it seems that RSA doesn't agree with Mr. Keeley as to what its own wording means, but it's a matter for you and us. The other thing I'd like to deal with as ground clearing is why the government did close here. I think we do need to briefly address that, because it goes to the 10 cases versus 20 cases and the million cases versus 8,000 cases. So just to remind you on the facts, and we can get most of this from the judgment, if you go to the trial judge's judgment, which is at tab 28, and you see at 381 some of the facts, and we see there, and just to remind you, this is in the judgment a bit later, the relevant dates for Excel, the first date on which national orders are relied upon is the 20 to 21st of March. So that's the key date for us. If you see paragraph 22 to 28, you especially look at judgment paragraph 22 and then 24, you'll see facts about what facts the government had, limited testing, and then at 25, total number of actual cases being higher than reported cases. And then at 26, this is a reference to the models that the government had. There are some models that came later, but the three here they had at the time and were referred to, and they're listed. And all of this comes verbatim from the agreed fact, so none of this is disputed. Other than the second sentence of paragraph 27 and the graph, which came from me and my junior, but the judge accepted there, it's almost illegible, but there's a clearer version at supplemental bundle tab 1. Page 13, I think. No, that must be wrong. Sorry, it's in our opening, so it's not. 256 tab 38. Not put a tab. So that's our tab 38 at page 268. This is the information that the government had, and it's the information that the judge was considering. And you'll see there the table of reported cases. At the 20th to 21st of March, I think it's agreed that the actual number of reported cases was something like 8,000. And then the modelling, and this was all before the judge, the modelling shows, depending which model you use, that's the three other colours on the lower graph, that if you look around the 20 to 21st of March, you've got between 1 million and 2 or 3 million, depending which model you look at. So this is why the government shut the whole country down. Not because of 8,000 cases, but because it thought that there was 1 million to 2 to 3 million. And then if we go back, we can leave that now. If we go back to the judgment, paragraphs 36 to 41. We see references there to Sage minutes where the government explains that it knows there's lots more cases than have been reported. So paragraph 37, for example, says on the 12th there were only 1,801 cases, and on that day, the government retreated to testing principally within hospitals. It didn't have testing capacity, so at this time of the lockdown, there actually wasn't much testing outside hospitals. And then you can see in those paragraphs, which run down to 41, references to Sage minutes about how there's far more new cases per day than there are reported cases, hence effectively reflecting the modelling. Now, what we understand the insurers therefore to say on this appeal, firstly, none of the business premises that had within them the million or millions of inferred cases to which the government was responding can claim, because the government didn't know exactly where they were. It didn't have a million dots on a map that could be zoomed into with an address. And to be clear, there was some more information than they're just around the country. There's references in the government statements to London is ahead of the rest of the country, and you might even recall those from the speeches that were given at the time. But overall, the position was they had modelling at a pretty high level of abstraction in that it was done by area, and of course they didn't try to identify the million street addresses, or the 3 million, depending. So if we assume that my client can prove that there were 100 or 1,000 or 10,000 people who went across its premises, which included a public walkway between two DLR stations, and the defendants now accept that there were occurrences at the premises because there must have been. If we assume we can prove those cases, and the government modelled that there were 1 million or 3 million cases at unknown locations, It's clear the government was responding to those 1 million or 3 million cases. It's clear some of those 1 million or 3 million cases were at the premises. And then we see, as you've appreciated already, the narrowness of the insurer's case, which is, well, it's because although they're responding to those cases that they inferred and modelled, that did actually exist. They believed they existed, they did exist. But because they didn't know the address, later we find out the actual cases were at the premises. That's not good enough. And we say that's unrealistic as a matter of epidemiological modelling. It's not going to be the case with these diseases. Once you get beyond a street, it's not going to be the case that you have a list of addresses. Indeed, the insurer's case is that not even a policyholder who had one of the 8,000 reported cases can claim. Because the 8,000 reported cases were for the large part, and this I don't think is disputed, reported from hospital tests. And no one's ever suggested that the government was told where the patients who had tested positive had said they have been in the last 2 weeks or 3 days. So all the government knows is there's 8,000 reported cases dotted around at probably all of the 1,000 hospitals in the country. We don't know where those people have been. So no one will be able to claim. Because even the reported cases are not reported at the premises, unless you were a hospital. But these policies obviously don't cover hospitals with disease. And nor would, even on a smaller scale, nor would a policyholder ever know. They would never know that the authority had a belief, and indeed that the belief was reasonable. So the insurer can say, well, it's true actually, the authority did say that all of the nurseries probably have such and such disease, but we don't think that's a reasonable conclusion for them to reach. You're going to have to prove that was reasonable, which I don't even understand why they require reasonable, because it's not necessary for their case. But even leaving aside reasonable, it's going to be impossible to be able to prove this sort of thinking within the mind of the public authority. Of course, you can draft that in. You can draft in something that's hard to prove. But would the parties have reasonably assumed that that's what was intended in relation to a clause that just says that the disease caused the government action? Of course, there could be difficulties even there if the government does something you don't quite know what it's doing, but it's likely to be pretty straightforward because you'll know what disease is causing it, and then you prove you had a case. So that's the stark numbers, and the best the insurers can do, and even those examples don't work, as we'll see, the best they can do is the example of 10 and 20, because then they can say, well, maybe there was a list. But even with closing down 5,000 places where you know of something at 3,000 of them, you're not going to have a list. These are fast-moving diseases that you're responding to in order to prevent spread. There won't be a list of the 3,000. It just doesn't work that way. You'll have information at some level of generality, which will mean the insurers are construing the clause to almost always fail. And they could write that in. They could write that in. But it just doesn't say those things. And Mr. Keeley tries to derive some sort of an ought from an is by saying, well, there could sometimes be some cover, and therefore my clause, the ATP, which I accept is not quite, by a small margin, as favourable on this argument to policyholders as the radius clauses. That's true, because there is one additional argument on the radius clauses, which is the one that Mr. Keeley identifies, the externality. But with everything else, which we'll go through, the fact that you've got, it covers only human contagious and infectious notifiable diseases. It's not just disease, it's not just danger. It explicitly includes not just public authority, it explicitly mentions governmental authority. It refers to occurrence of disease. Why occurrence? Why not manifestation? If what you're talking about is that they're responding to knowing about the disease, why not manifestation? It refers to occurrence or outbreak, which was a term that the Supreme Court found very important as not being present in the disease clauses, as I'll show you. So all of these features mean, and Mr. Keely's barely gone to the clause, he's not addressed those words. All of these features mean that any reasonable person looking at the clause is going to be thinking fast, widespreading, unpredictable disease that may well lead to undifferentiated governmental response. Why do I say governmental? Because the word is in the clause. Governmental response. That probably doesn't include a list. But would I have cover? Well, yes, unless someone says otherwise. They could say otherwise. They could say caused by a case of disease at the premises by reason of being at the premises. They could have at least included the word direct, which is a point that's already been adverted to from the bench. There's lots of things they could have done. And it's simply wrong to suggest that any qualification within a peril, which is the gateway to being able to claim, has some significant impact for the causation. For example, this is a silly example maybe, but it has to be a notifiable disease. What if the government acts in relation to it to close it down just because it's dangerous? Not because it's notifiable. Can they say, no, it has to be notifiable. The notifiability has to be what caused the government's action. Otherwise, why would we require that? The answer is they're qualifications to the gateway to the peril. And there is no precedent. Of course, it's right that one considers what's contemplated within a clause, but there's no precedent for considering a causation test along the lines Mr. Keely suggests, or for his distinct cause test. So it's very clever. It's a way of saying, well, I'm not going as far as I went in the Supreme Court with the but-for test, but I also need to come up with something reverse engineered that the parties would not have thought of that saves the insurers here. And it's pretty nuanced, and that of itself reveals that the reasonable parties would not have thought of it. And when we're debating it about kebabs, etc., we're not at the margins. We're not saying, oh, well, it's at the very edges of the clause, it's hard to understand. It's just hard to understand. Even the 10 out of 20. Let's take Mr. Keely's example. The reasonable policyholder, he says, would, when reading the clause, think, well, it must be by reason of the being at the premises that causes the action, he says. 10 nurseries or restaurants are closed, 20 are closed, 10 we know have the vermin or the disease. But the local authority or whatever authority decides to act on all nurseries or restaurants or all in Upper Street, etc. Can the insurer not say to one of the ones that does have the vermin and the disease, well, no, you're being shut down because you're a nursery. All nurseries are shut down, irrespective of whether they have the disease. In what sense did your disease even cause the action? That may be why he doesn't adopt a but-for test, because he has to have wriggle room by having a targeted test that can respond whenever there's a problem. But how does that work? How do you say it's targeted? It's distinctly targeted at the 10 where there is a disease, when all the nurseries are shut down. Blanket, generalised. Or to put it another way, and I think this has also been put, I think, to some extent by my Lord of Justice Popplewell. Why does this nuanced difference between, even with a general response, the authority knowing or believing you specifically have a case, or not knowing or believing you specifically have a case, but maybe suspecting it or knowing you might, who would think that makes the difference? And that's all the difference that Mr. Keely is trying to engineer here. Who would think that? It's hard even to contemplate. So I'm going to come back to some of those points of vermin, etc. But if I may, I'd like to go through the test case as Mr. Keely has. I won't say exactly the same things he said. And I also would like to briefly just defend the judge and also, by extension, Mr. Justice Cockerell and Lord Muntz, because they also broadly took this approach. The approach of taking the Supreme Court and seeing, is our contract different, is not the wrong approach. Because the Supreme Court found various things on a similar wording. And you should always end up at the same place if you say, is my wording different in a material extent? Can it be distinguished? That is how we reason in a precedent-based system. Now, of course, there are individual contracts, and one must address that question wholly and fully and honestly. And it has been many times now, and the answer has always been, yes, it's the same reasoning because the distinction doesn't matter. Because the point that Mr. Keeley makes, and it's a real point, it is true that there is a difference between an external and an internal in the sense that, in this sense only, a radius clause does necessarily, or as he says, intrinsically contemplate that the case outside leads to the interference inside. But that was not central, barely even peripheral, to the court's reasoning. And the reasoning that they did have does apply here, quite apart from the additional points we have on our own specific wording. So, just if we turn up the judgment, which you've been to already, it's authorities.
Supreme Court judgment.
Supreme Court judgment, authorities to. The first main section on the substance starts at 48. Section 5, disease clauses, and runs all the way to 95. You can see the issue summarised at 54. And then we have, and we've been to this already, 56 and 7, which are two matters described as fundamental by the divisional court. So I think my learned friend said, oh, one has to read this in a particularly way because it might be a legatism in some way. But this is a summary of the divisional court, and it's a faithful one. And we see there, and it's echoed later, and I think my learned friend said this also correctly, these two fundamental reasons were fundamental reasons to the divisional court's finding said to be wrong as to the scope of the peril, but they were later explicitly adopted by the Supreme Court as nevertheless correct factors when construing causation. So, we have the first, which is just the textual point. It doesn't say only. And my learned friend says, well, that doesn't apply to him because he's not saying only either. And that's true, but there are lots of other things it doesn't say, such as directly, and I'll come back to those. And then we have 57, which we looked at in some detail. And however you cut this, and it's true of 1, 9, 4, and 5 as well, the focus is on the nature of notifiable disease. I know that because the first sentence says it's about the nature of a notifiable disease. I pause there to note that our clause is not all notifiable diseases, it's only infectious and contagious ones. So there could be an argument for some of them as to whether they're truly contagious. It depends on one's definition of contagious. But that's not a problem for us. Ours are only human infectious and contagious diseases. Going back to 57, we've got the list of diseases, cholera, etc., which are capable of spreading rapidly and widely. It's also open-ended. There could be new things. It may potentially affect a wide area and cause interruption to businesses over a wide area. Stop there. Those are facts that cannot be disputed, and I think are not. The nature of the notifiable diseases, so this is not the parties contemplate. Who are the parties contemplating? This is the words of the clause. It's a clause about notifiable diseases. It's headed infectious disease extension. these diseases can spread rapidly and widely, so wide outbreak, and could potentially affect a wide area and cause interruption over a wide area, so can lead to wide government action. Then, dash, a risk clearly contemplated by the policy which recognises the occurrence. So this is Mr. Keeley's point. The 25-mile clause itself contemplates that you could have something affecting a wide area. But that's an illustration. A risk clearly contemplated by is saying you can see that the policy contemplates that by this specific wording. This just shows my point, me being the divisional court, which is that notifiable disease means these diseases are, and those were facts, and there were facts about the diseases. So the nature of notifiable disease doesn't go away if you don't have a radius clause of 250 metres, 1 mile, 25 miles vicinity. And therefore, the parties must also have contemplated, also because of what was said earlier, that they're wide diseases. A wide action in response to disease as a whole, not to particular parts, and that it would be irrelevant whether the cases fell within or outside a line 25 miles away. In other words, that the reaction is generalised over the outbreak. And you can just replace that with whether it fell within or outside the premises. So that is the divisional court reasoning as summarised by the Supreme Court, and then 58 gives the conclusion that it must be intended to cover that. The majority of the Supreme Court disagreed with that conclusion as regards the peril, as we know, partly on textual grounds, which is at 61. It's talking about an occurrence, not the whole pandemic, etc. But also, you then see the conclusion at 66. Sorry, part of the reasoning at 66. You see, interestingly, rejecting the FCA's construction of the peril, the Supreme Court said the insuring clause refers to occurrences, so it must be the occurrence within the radius. It can't be just that the general disease outbreak has gone within the radius, which was essentially the FCA arguments. But they then say in 66, if it had referred to an outbreak, that would have created a problem of deciding what that means. But it would have favoured the FCA's construction. Now, I'm not arguing for the FCA construction of the peril here. We're sitting on the peril that we have. But the point that I make is that or outbreak is in our clause, and therefore is an additional wording that does contemplate this broader extent of the disease. It's not a major point, but it's a detail of our wording, which we say favours our construction of the causation. 72 is the only argument again, and it said, well, that's relevant to causation. And then 73 is a repetition, so it's saying the court below was wrong about the peril, but we do agree that it's significant, the potential for a notifiable disease. This is of the nature of the notifiable disease. For a notifiable disease to affect a wide area, and for the occurrence within 25 miles to form part of a wider outbreak. That's nothing to do with, they must have contemplated that the disease 25 miles away causes what happens in. That's a separate point. This is just saying how wide is the outbreak and the response. And then 74 summarises the conclusion that peril is limited. The FCA and the divisional court were wrong about that. And then there's the question of causation. Just in passing, as we flick through, I'll just remind you at 94, it reminds us about the 1 mile clause. Although in the context of peril, but you'll recall that the 1 mile clause has the same answer as the 25 mile. And the same is true of the Hiscox hybrid 1 mile clause. And my learned friend accepts that and says that's okay because the same principle applies. Then 160 onwards, we have causation. Heading 7. And 161 summarises the peril conclusion. It's a narrow peril. You could say it's a local peril. Especially for a 1 mile or a vicinity clause. It has to be local. That's the nature of the peril. The FCA argument was rejected. The peril is only the disease that's local. That's all. And we then go on to consider causation. But that's important for an additional reason. Because although Mr. Keeley says he's distinguishing the Supreme Court reasoning, he's really repeating the arguments rejected there. And those arguments were versions of, because the peril says the disease must be within 25 miles, 1 mile vicinity, 250 metres, that must have something to do with causation. That's what he says today about at the premises. That was the gist of the argument there. It's a local peril. The insurers won on that point on appeal. It's a local peril. It does not include the entire pandemic. That is not the peril. The peril is only occurrences within. And then you have to get to causation. How does causation expand out so widely? And there is no explanation for that Mr. Keeley can give. Not least because he's probably not happy with that conclusion, because it wasn't what he argued for. But there's no explanation for that because the arguments can still arise. Well, surely the disease within 1 mile must have had something to do with the public authority action. So I should be closed down because I'm local to the case. That case, at least, must be something to do with what the government's reacting to. Because otherwise, there's no causal nexus between the case within 1 mile or 25 miles and the government's action on Mr. Keeley's case. So he can still, unfortunately for him, his reasoning works against the policyholders in the test case also. He would still say, well, there may be generalised responses, but there are also ungeneralised responses. Leicester was closed down because of the cases that are within the 25 miles or the 1 mile. And the insurers relied on Leicester as how the policy should work. And therefore, it could be said, well, in a national response, there's no recovery because the government isn't responding to the localness. It's not responding to any of the particular cases. So the argument still works and therefore still doesn't work in the test case as here. We'll come back to that slightly later. 161 we just looked at. If we go to 162, the particular formulation as to proximate cause doesn't make much of a difference. And then we go forward to the key paragraph of 176, which we have looked at. Sorry, we have not 176, we haven't looked at. 176 is the conclusion on concurrent causes. And it notes the important finding that the government measures were taken in response to information about all the cases of COVID in the country as a whole. And just pausing there, all the insurers agree, other than AXA, that that means the government was reacting to unknown cases. And AXA has an additional argument on that, as you'll appreciate. Jumping forward to the reasoning, the core reasoning at 190 onwards. So we've got 191 is very important. The point made there is that there is a causal connection. This is a finding of the Supreme Court that's not related to the particular cause. there is a causal connection between an unknown case of disease, one of the million or the 3 million, and the government's action. The only question is whether it's enough of a causal connection for the proximate cause test on the proper construction of the contract. But the starting point is, therefore, that the reasonable person would understand that in a generalised response to a case that's unknown, where the government or the authorities model some cases, does have some causal connection with the reaction. Doesn't satisfy his targeted test, but it has a causal connection. And we've already seen that the generalised response is something that may well happen in reaction to a contagious disease, and a wide area response is likely. When you've got the government, whilst they may react to individual cases in some circumstances, you can well understand that when you've got the government, you're going to expect a broader response. So when the policyholder has those facts, and they know that cases can have a causal connection where there's a generalised response, what in the clause is to tell them that their case at the premises didn't result in the government's action? How are they to know that? Oh no, that causal connection isn't enough. Results in means targeted. It has to be known even though it's just an occurrence. There's nothing there. And these parts of the Supreme Court judgment are important. There may be findings of fact there, but they're not disputed. There is a causal connection in this generalised case. My learned friend didn't like it then and he doesn't like it now, but it's a fact, and it's well to be contemplated where you have wide area response. So then, if we go on to 192 and following, we have the construction exercise. You see the last sentence of 192, which I think we agree was the question that was being asked. And then we have 194. We've looked at this already. And if we go to the second sentence, the parties to insurance contracts may be presumed to have known some infectious diseases, including potentially new disease. So this is an echo of the original thought, summarised version. It spread rapidly, widely, and unpredictably. And it's obvious that an outbreak of an infectious disease may not be confined to a specific locality or circular area delineated by 25 miles. So it's obvious also that it won't be confined to the premises. It's even more obvious. And this doesn't rely, and nor does Mr. Keeley say, this relies on the external point. This is about the case further away having led to the authority action that interfered with the premises being external. This is just a sentence about how plainly the outbreak can be wide, and where you've got at the premises, it's all the more likely because beyond one premises you're already outside the area. And then we have the next sentence. No reasonable person would suppose that if an outbreak of an infectious disease occurred, which included cases within such a radius, and was sufficiently serious to interrupt the policyholder's business, all the case of disease would necessarily occur within the radius. Now, Mr. Keeley says, the word and impliedly says, although it's not mentioned, impliedly says that because radius clauses intrinsically contemplate action from without premises, you must be looking at a particular type of potentially generalised response. The and just means that the outbreak is sufficiently serious that a public authority has closed some businesses. That's how serious it is. Because a lot of diseases don't lead to businesses being closed, but the premise of any claim is that the policyholder's business has been interrupted. So it must be quite serious. That's all it's saying. If what they'd meant is, it's not really about the fact that it's notifiable disease that matters to us. The key feature here is what we mentioned in passing the divisional finding, we don't even mention here. The key feature here is the fact that there's external cases causing the interruption at the premises. Well, they would have said so. I don't say it's not an additional point that could be made by my client at the time, but that doesn't mean it was important to the reasoning. It wasn't. It's not mentioned, it's not explained, and the reasoning repeatedly refers, and there's a couple more references to it, to the nature of the notifiable disease. That was the crucial feature of these cases. And the same point applies to such an outbreak. It's just referring to an outbreak that's serious enough to close businesses. And it's an outbreak of a notifiable disease. Very serious because they can spread widely, etc., etc. At 195, here's the point that therefore, and my learned friend accepts this for our clause as well, show you that going in past. Keep the judgment, but just find a skeleton. Four bundles of 8. I think it's at paragraph 63 and then 64. You'll see at my learned friend 63, it's accepted that occurrences of notifiable disease, this is the disease itself, are inherently capable of combining with others to call for a response that's not solely attributable to cases within one specific area. The judge observed this as true in the context of ATP, and the following market accepts that this is right so far as it goes, and they accept 195 to 196. Now, my learned friend seeks to avoid that by a form of paradigm argument where he keeps saying this is not a paradigm, but actually the case the contract's really dealing with is a specific case, and we'll come back to that. If you just see in 195, it said that you can't be intending, because of the expectation that the response and the cases will be outside the locale, which includes at the premises, my learned friend accepts, you can't be intending the cases outside to compete with the cases inside. And he therefore accepts the but-for test doesn't apply. That's very clever because it seeks to find a middle way, as I've said. But it doesn't make sense. On his reasoning, we heard him this morning, the government may well respond to individual cases. It might close the meat packing plant. It might close the Excel centre on its own. It's a very big place. Lots of people go there. It might just act on individual premises. So if that's the case, why doesn't he say, well, the parties might contemplate a wider response that doesn't satisfy the but-for test, but the contract doesn't, because the core thing about the contract is that it's a disease at the premises. So why not just have a but-for test? If you're just going to close down individual properties, then that will be covered. Why would the parties think you'd go further? So his argument proves too much against himself. He doesn't really explain why he's in the middle. And this is probably why some insurers, although their argument we think is terrible for different reasons, stops at but-for, because they don't think there's a middle way. Because once you accept you've got wide area disease and wide area response, and that the but-for test wouldn't fit with the party's intentions, there's nowhere to go other than where the Supreme Court went. There's no basis, there's not even a hook to hang targeted or distinct. that's a convenient moment for the 5-minute break.
Yes, very well.
All right, able. Relax and Anya will be putting the silver on Jeremy's side.
I thought about
Is that being bought? Hello. Yeah. Oh, sorry, slide contract. This is getting progressively helpful.
Spending cuts. Can't afford electricity.
No, pardon?
Explaining to someone before that the Manchester Logistics Centre's got fantastic, immensely fantastic airflow system in the air conditioning. Really?
However, it doesn't work. So now you can't have air conditioning.
Because they haven't got the ducts.
Well, I think there's some built in. It's got a huge glass front on it as well.
So it doesn't work.
It's either boiling up or freezing. Rarely into.
Oh.
Probably looks cool. Well, it would have been in the Crown Court building.
I didn't possibly.
Well, it was probably around that time.
Maybe it was like in the middle.
Reference of Brendan Hegarty there.
Was it caution? One interesting case. It was all about these footballers. These people that but these were massive. My client.
What did they strap?
That the kids were like life-size transfers that they could put on their wall. I think we were being sued by a Premier League something, infringing the image rights. I think we won, and I can't remember much else. Stadium awful. It was near the station. Was it the Britannia?
Oh.
Horrible. Horrible. Really. It's probably a lot worse now.
Sure it's a hotel.
Did it?
Look at these holes. Look at these. You put in figures into the electrical documents, you get the toy party. Look at it go. So it's a good discipline to have it first. Yeah. I was asked to stand in Brussels because she's got COVID, but I said, unfortunately, it would have been an excellent opportunity.
Court rise, if able.
Lady. The next topic considered in the Supreme Court judgment is at 198-205, and that's the weighing approach. This was Mr. Crane of QBE. He argued that even though the peril is engaged by each individual case, for the cases within the radius to have been proximate causes, the totality of cases within the radius must be weighed and see whether they were at least an equal effective cause of the public authority action. So it's another middle way, and it's a middle way a bit like Mr. Keeley's, because what it does is it says you have to take seriously the fact that the peril refers to only cases within a radius. And that has to have implications for causation. And for that to work, he proposes that we ask whether the totality of cases within the radius was at least an equal cause in a weighing sense with those outside. And so if you have an outbreak that happens to go outside the 1 mile or the 25 mile, that doesn't matter, providing the cases within are at least sufficient to count as an equal cause. And that was rejected. We see at 200, firstly just in passing, those two sentences are a repetition of the point that cases of disease combined to cause loss would not have resulted from an individual case. That is what would normally be expected to happen. And precisely what has occurred in the present case. And this is because of the nature of notifiable disease again. But then at 202, there's a focus on the unworkability of this test. you see the second sentence. Suppose some restrictions were imposed in response to an outbreak, partly inside and partly outside. It's difficult to see how the weighing approach could provide a rational basis for determining whether the cases within should be regarded as causes. It would be a complex inquiry, assuming you could obtain this information. The next question is what number counts, what percentage? And then at 203, the still more fundamental objection is that it sets up disease outside in competition with disease inside. And so the weighing approach was rejected. And at 204, the conclusion is reached towards the end of that paragraph as to why, and Mr. Keeley referred to this, why essentially you have an arbitrary limit which does affect your risk because there still has to be proof of cases within, and so the smaller the radius, or indeed down to at the premises, the fewer cases will be covered. Claims will be covered, sorry. But that was in response to the argument that that part of the peril must have an implication for causation, and the answer was no. It's just restricting the risk, it's providing an arbitrary limit. It does not have an implication for causation. The weighing approach is rejected. And the judge referred to this point of the insurers and said that the insurers were essentially adopting a similar approach to Mr. Crane, and I think he accepted my characterisation that Mr. Keeley was adopting a qualitative weighing, whereas here it was a quantitative weighing, just because of the nature of what was being discussed. But essentially it's the same thing. Mr. Keeley's saying, in the mind of the authority, did the case at the premises play enough of a part? So on a very small lockdown of 2 named premises, then probably yes. And on a larger one, probably no, because you don't end up just listing premises, as I've said. So it's the same sort of argument, and the answer is the same. The peril defines the peril, but the fact that it has to be within a mile or here at the premises, and notifiable, and anything else more than 24 hours or whatever the clause says, those are requirements that don't necessarily have any implication for the causation test. And they don't where you're dealing with notifiable diseases, repeatedly stated by the Supreme Court as contemplating. The word notifiable disease, contemplating. Widespread, perhaps nationwide, but in any case, perhaps generalised. Reaction. So then we have the conclusion, 206. It's the first sentence summarises the preferred approach. Each case of disease, third line, informs a decision to impose restrictions and treats each such case as a separate and equally effective cause, irrespective of its geographical location, the locations of other such cases, and that avoids irrational effects. And it accords with the presumed intention of the parties and a product sold principally to SMEs. Same here, exactly the same here. The individual case in the government's reaction did have a causal connection, that's not disputable, even though it was unknown, especially here, because there were so few reported cases and so many modelled cases. Why? Because testing was way behind the spread. So when that's the case, you have a generalised response that is almost entirely to the modelled cases. It's just not to individual cases. And fast, wide-spreading diseases will often have those characteristics, that in the early stages of the pandemic, or epidemic, or outbreak, there's a reaction that attempts to act early on the basis of information that, in terms of actual cases, will always be historical, even if you have a test for the disease, which you don't for a novel disease. And it will often have to act in this way. And that causal connection was enough here. each individual case was a cause, and there's no reason why it isn't in the ATP case. And I know Mr. Keeley doesn't like me saying that. He says, well, start with this contract. But those findings of a causal connection are common ground now. What the government was reacting to is common ground now, apart from AXA, who tries to rewrite the Supreme Court judgment. So those being the facts, what in the clause tells anyone that that sort of causation, perfectly sensible and expected, isn't enough? And you could put something in, as I say. If we go to 212, you have the formulation, conclusion, and this is therefore the end of the disease section in that judgment. And this turns into the wording in the key declaration. Loss from interruption, second line, was proximately caused by one or more occurrences of illness. To prove that, it's sufficient to prove the interruption was a result of government action taken in response to cases of disease, which included at least one case of COVID-19 within the geographical area. The Supreme Court said that the government was acting in response to the cases of disease. That turned out to have been in particular places, but it was acting in response to those cases. It just didn't know exactly where they were. So even if, and it's wrong, but even if the reasonable person would think, oh, this clause must be getting at the case in the premises, the authority acting in response to the case at the premises. Well, that happened. The Supreme Court has found that that happened, even though it didn't know where they were. That's why he doesn't say in response, he turns it into targeted. We then look at Lord Briggs's concurring judgment, which starts at 316. Sorry, it starts at 314, but the reasoning, the core of the reasoning starts at 316. I'm slightly ruining choosing A5 bundles, but in very small writing. Consequence, therefore, is that, on the insurer's case, the cover apparently provided was in reality illusory. And then, going down the page to the bottom, as the majority show, which is about 6 lines up, there were a number of well-known notifiable diseases to which the relevant clauses clearly applied, all of which were capable of spreading rapidly and widely, so as potentially to cause a threat to health on a national scale, and to threaten a national reaction by the responsible authorities, leading to business disruption on a national scale. There's not even an additional, this is shown by the 25-mile clause. There's no reference to Mr. Keeley's external point here. It's because the nature of the disease is such that they could cause a threat on a national scale. This is could at the time of construing the contract. He explicitly says higher up, this is not to use hindsight. He's talking about what notifiable disease means. That is the reasoning. And any disease clause is going to satisfy that reasoning, unless there's some wording that says, no, a more narrow causational test will apply. We'll actually see that the case law applies this same reasoning even where the clause doesn't mention disease. That's the prevention of access clauses, which talk about danger and emergency. But even then, because they can contemplate disease, the same causational test has been applied in Forward and King. But here we have a disease clause that explicitly refers not to disease, but to notifiable disease, not to notifiable disease, but to infectious and contagious notifiable disease. And these are the factors of it that give rise to the construction conclusions of the majority and of Lord Briggs. We see 319 at the end as a reference in the ultimate sentence of 319 causes this point's not really a point against Mr. Keeley. This is against AXA, who still say, no, the Supreme Court were only ever looking at the 8,000 reported cases. Clearly, they're talking about 1 million cases, and we know what 1 million means, because we've seen the models. In that context, it is worth mentioning paragraphs 321 to 325, which, and the end of 321 refers to 1 million again. Mr. Keeley referred to this, identifying Divisional Court's peril analysis, which was that, on his view, the construction conclusion could also be, as the Divisional Court said, that the peril was the entire spread of disease provided there was a case, which he thought was equivalent and it didn't matter, and he was content to agree with the causational analysis. But that also is the death knell for the AXA case, because on AXA's case, they're very different. On AXA's case, causational analysis does not lead to the conclusion that providing these cover, because they say, no, it's just the causation case, knowledge. And that's obviously a complete peril as construed by a division. So that is another nail in the rather porous coffin of AXA's case, but I'll leave others to deal with that. If you look at also at yeah, actually we don't need to see that. That finishes off at 324, that reasoning. Just turning to the judge's reasoning, which we summarise the judge's conclusions in our skeleton, but we don't go there, paragraph 18. If we go to his reasoning, which you'll recall is prominently filed at tab 28, core bundle. And you'll see paragraph 194, we engage with his analysis of the Supreme Court's reasoning. He introduces his reason at 194. In one respect, the reasons which led to the Supreme Court's conclusions are equally altogether. His argument is not the same, but he reached the conclusion that Mr. Keeley's point was not part of the Supreme Court's reasoning, and rightly so, we say. The main reason is at 195, first, and this is the nature of the diseases. And I've made the point because the Supreme Court made the point. That is the starting point. You're covering something that of its nature and with these sorts of diseases, more than potentially, probably likely. Not necessarily national, but broad. And in 196 and 197, he summarises his reading of the Divisional Court and Supreme Court to that effect. And then at 199, he rightly says it's equally applicable to at the premises. The diseases covered are the same, so are their potential to be widespread, and to call for response which is not solely responsive to cases within the radius or the premises. That can't be disputed, and it's not disputed. And he talked about it being inherently likely that, one would normally expect case of disease to combine and cause loss, which is true here also, because it's the nature of the disease. And that's the core point. These are disease clauses. There's going to be an appeal in relation to prevention of access clauses and NDDA clauses, which, as I say, I'll touch on the law on those, but those clauses don't use the word disease. They mention danger or emergency or that sort of thing. And in those clauses, Mr. Justice Jacobs was also of the view that the same causation test applied, to the point where, and I'll show you later, the parties agreed not to argue it and that he would just give permission. And that's been given, and that hearing is coming up at an unknown time early next year. Possibly January. But those clauses, Mr. Keeley says they're easy because he's conceded. I don't think all insurers agree with him. He's conceded that those clauses do have the same causation test because they're not at the premises clauses, they're vicinity clauses or immediate vicinity or that locale. But on one view, they're more difficult than this case because they're not disease clauses, and I'll show you that that doesn't ultimately make a difference. But this case is an easy case because it's only about highly spreading notifiable diseases. So it's not possible, and even our case, which is only contagious diseases, so it can't even be about legionnaires. And my learned friend has an example in his skeleton of what about shutting down premises to clean where they've got fomite transition, meaning transmission from surfaces. But he can't name one of the notifiable diseases for which that's the primary method of transmission because they almost entirely transmit by water droplets and water drinking and things like that. So we'll come back to the POA or NDDA clauses briefly, probably tomorrow. But here we have...
Well, by all means, show us those if you need them for your argument in this case, but we're not interested in trying to decide the next case.
Absolutely. But the reasoning of those judges as to how the Supreme Court, what the ratio of the Supreme Court was, is, we say, correct and therefore illustrative. But I will see how much time I have, of course. The second argument the judge says in paragraph 200 is that the Supreme Court referred to the width of the radius and that it will be likely that you'd have cover outside and inside, and the affected insurer's argument was to deny cover. And then 201 is Mr. Keeley's point, fundamental distinction. So this is his external or internal, although I don't think he formulated it in those terms then, but that was his point at 201. And at 202 that's rejected. He says the fact that they agree the same reasoning applies to any very small vicinity or locale clause means that doesn't really help the insurers. And the key, he says, in my view, which is the third sentence, fourth sentence, halfway, well, sorry, 6 lines down, in my view, towards the end of the line, illustrates the first point, namely the nature of the disease is covered. And I don't think it can lead to a radically different test. It's not the existence of the radius, which means that there may be non-premises specific wider area authority action. It's the nature of the diseases which are covered. We say so too, and Mr. Keeley, as I said, broadly agrees that. He just says it's just something that the clause decided not to cover, but unfortunately for him, there's nothing in the clause to do that. So 203, the judge says, well, the radius can vary, but the Supreme Court doesn't seem to bother about that. And Mr. Keeley says, well, that doesn't help the judge because any radius is different to no radius, and I can see that obviously that's not exactly to his point. 203 second sentence, though, there wasn't necessary to be discussion because the principle was the same, and it arose from the nature of the diseases covered. That's why it doesn't matter. Because although Mr. Keeley, and he's found the only difference between a radius and a non-radius, and so he says that's the key. But unfortunately, commonalities, nature of disease especially, remain. And just by repeating one point many times doesn't remove the importance of those other points which remain true, and the additional points that we'll come to in our clause. 204 then deals with a further reason, which is that the function, let's say this is the second sentence, the function of the radius is simply to define the area. And he refers to the Supreme Court often talking about the area, and that one area is bigger than another, a bit like a different excess or some other variety in an insurance contract, but it doesn't necessarily dictate anything about causation.
Well, all of these paragraphs up to 207, where he deals with the third point, is that it's not the radius but the nature of the disease. There are variations on that theme, aren't they?
It's true. I am responding to Mr. Keeley's repeating his one point by repeating the reasoning of the Supreme Court that I say, but I do have the advantage that mine's in the Supreme Court reasoning. But you're right, my lord, and the judge does the same there. That's true. His third reason, just these are a bit less important, but thirdly is at 207, was that only, and I've touched on that, the wording we could have had here. And then we have 208 and 9 on the extra point. And fourthly is the 210, the workability. We'll come back to that as well a bit later. There's, he does refer, slightly hesitant to mention, I think it's a FOS or Ombudsman decision when I'm now in the Court of Appeal. But at 156, he refers to the reasoning of the Financial Ombudsman Service, which a brief part of it is in the bundle at Supplementary Bundle 69. And that reasoning, for some reason, is not all in the bundle. There's only an extract, but we can provide it if you want. It's just the FOS. I say just the FOS. It's just the FOS, and the judge says, well, it should be just treated a bit like an academic article. But it's a very detailed and well-reasoned decision on an ATP clause, and the only one that we have. And so I would commend it, although it's hard for me to do because we've only given you an extract, which at least you can read. But that's one of his other, it's the only other authority, but he treats it as, I think rightly, just as some reasoning that's persuasive if it's persuasive. So I think we should turn now to the XL wording itself, which I think we've probably taken out of your bundle, but if you haven't, it's at 4 bundle 30.
Because when I do
Yes,
that,
you
I
might
usually lose it.
It's on your screen, but this might be the least used opus that I've ever had. But it is there if you need it. Page 539 is the infectious disease clause. I'll come back to the NDDA clause, which Mr. Keeley relies on. And some of these points I made already. If you...
I think we were looking before at page 557, but
Were you? Oh, sorry. Well, we can look at, sorry, you're right, you're right. 557 is there's multiple, but I think we've agreed to use 557, you're right.
it's all the same, presumably.
Same. So, the points, and it is worth looking at a clause. Mr. Keeley constantly said it's important just to look at the contract you have, but he didn't really do that. We have closure of the premises on the order or advice of a local or governmental authority. Now, the governmental authority, as I've said, but you can see it here, it necessarily contemplates a wide response to a wide outbreak. Yes, the government could react in another way, but when you get to the level of government, you're obviously expecting that if your premises, and your premises might be small or might be large, if your premises are affected, that they're going to probably be because the government's taken an interest, and that's probably going to be because there's a big, not necessarily national, but a big widespread outbreak to respond to. my learned friend touches on this at 89 and says, well, it's just a possibility that there's a governmental authority. But the governmental authority is there in the clause. It's one of the two listed, and these are the sorts of points, obviously, can go both ways. Sometimes someone says, your clause only says public authority, doesn't mention the government. And they're not that strong because public authority includes governmental authority, just as danger includes disease. But explicitly mentioning it is relevant to what the reasonable person's going to be thinking his clause or her clause is covering. You also have any human contagious or infectious disease other than AIDS or an AIDS-related condition. So, an outbreak of which is required by law or stipulated by the governmental authority to be notified. So it's only notifiable diseases, but also only contagious or infectious ones, which, as I say, is a subset, although it probably includes most of them. It refers to an outbreak or occurrence. I made that point already, that the Supreme Court at 66 thought outbreak potentially quite significant in its absence in the clauses that the Supreme Court were looking at. My learned friend at 88 in his skeleton ignores the Supreme Court reasoning and just says outbreak doesn't really help.
Well, outbreak is a more demanding test for the policyholder to satisfy, isn't it? In terms of,
yes, I'd have thought
whether
so.
there is an insured peril.
Yeah.
Yeah.
Does the Supreme Court say, well, a single occurrence isn't the same as an outbreak?
It does.
And then you've got to see where you draw the line and say, well, now it is.
But that's true. But the nature of outbreak for the Supreme Court was that if it's an outbreak at the premises, that's not necessarily something that occurs in a particular place at a particular time, etc. So the outbreak could potentially open up the FCA's argument and the divisional court's finding that it's the broader disease epidemic that has to be at the premises by touching the premises, rather than being concerned about what's within the premises, or there, the radius. Whereas because the clauses considered there use the words of occurrence or similar, that argument was not available because the peril was clearly just what was within the radius. So that was the resonance. I agree with you that triggering it's harder, but here we're talking about what the parties are going to think is getting covered by this clause, and here they've got the word outbreak, which emphasises that what we're talking about is a spread of something.
But it's outbreak at the premises. What the Supreme Court were concerned to do was to draw a distinction for the purposes of the scope of the peril between an occurrence, one place, one time,
Yes.
and an outbreak in the general sense of the disease in the community. It wasn't looking at outbreak at a particular place.
Well, it was looking
But
at...
here we are looking at outbreak at the premises. So there isn't really a read across there, is there?
Well, I won't push it too hard, but the context of what they were considering was there wasn't the word outbreak, but they were considering outbreak within the radius. And they were saying, if it was outbreak within the radius, it may not necessarily be just what's within the radius, but with occurrence it definitely is. But I won't take it any further. It's not as important as the reference to contagion infection or the reference to governmental. And this is a non-barking point. It just says, as a result of an outbreak or occurrence. So this is, if we see our skeleton at paragraph, if you try to keep the clause, but our skeleton at paragraph 46, which is at tab 9, page 146 of the bundle, and then 147. We make the point that they didn't use the word direct, and that distinct is to an extent just a synonym for direct. They didn't use the word direct, although they used it at trial, in this clause. And then footnote 24 shows you lots of times that the parties did use the word direct, but just in other clauses. I mean, it's not a surprising result. Direct is obviously available within insurance clauses anyway, but it's used throughout the policy, but not here. They could have said, as a direct result, they could have said solely or such. And I know my learned friend says, well, that's not a problem for him because he's not saying solely. But you see the but for insurance, so advancing the case, effectively it's a direct cause. That's what they're doing. And so the point applies to them too. Our supplemental skeleton paragraph 4 refers to those references. So really, all these insurers are saying you must imply in the word direct actually something narrower, targeted. But really, you must imply the word direct or direct. And if we did have that word, it would be more difficult. But we don't. The parties chose not to use it and they use it elsewhere. The inescapable conclusion we say is that the trigger not only has the potential to be a widespread outbreak, extending beyond the practice, but that seems highly likely given the clauses, the words used in the clause. And the judge was firmly of this view, and when he reached his conclusion, it wasn't just on balance. He actually said in granting permission that he was skeptical as to whether there was even a real prospect of success. And did it for other compelling reasons. I had a short topic about the hybrid clauses, but I don't think we need to deal with the hybrid nature right now. I'm just going to check. Oh yeah, sorry. I have already touched on the point. It's really the point that, without going through it in detail, there's a long section in the Supreme Court judgment at 213 onwards. What happens there, we can open it, but I'm not going to walk through all of it. So ignore my prevaricating. I am going to make the point, so it's a brief one. The first paragraph there, 213, says, well, those disease clauses, those are the simplest. There's only one causation link between the disease and the interruption. Now we turn to hybrid clauses, which goes on to explain composite clauses. And they say that the nature of the they say in 213 the first step in the composite clause is, does the disease cause the public authority action? And they say, well, that's the same as the question we've just decided for disease clauses. So they read all of that in to the first question, and then they have to deal with a second question, which is the question of whether the government's action caused the interruption. That's not a problem for disease clauses, but it does arise for hybrid clauses. And the conclusion, without going through the detail too much, is that it does, even without the but-for test, because even if the business would have been closed anyway, because the other cause of the closure is a concurrent cause that arises from the same underlying cause of the COVID disease, it's still covered, because you can't use another disease-related cause as a competing cause. So you can see the conclusion all the way forward at 243, I think. So at that second stage, there's a similar issue, and no one here disputes, I think, that reasoning. The appeals aren't related to that reasoning. But we nevertheless say that the fact that the jurors all agree this, we do have to bear in mind that Mr. Keeley's saying that in our clause, there's a targeted or a directness requirement in the link between governmental authority and the occurrence of the disease, but that there's no qualification to the link further up between the interruption and the governmental authority. And we also get to paragraph 250, which shows the Supreme Court's reasoning and how specific it was or wasn't. where the Supreme Court says we don't need to address the other clauses because, as noted earlier, the issue does not arise. In principle, however, a similar analysis must apply. That last sentence has caused quite a lot of argument since, but the reference back from, as noted earlier, is, I think it's agreed to paragraph 122. Which is at page 160 of the bundle. Where they said, they being the majority, we consider in principle the same analysis applies to these other clauses. It's unnecessary, and the reason why they don't deal with it later is the same reason they don't deal with it here, which is second sentence. It's unnecessary to address this separately because the court below held that for other reasons the clause does not cover losses arising from the pandemic. There's been no challenge to that decision. So essentially some of the clauses weren't appealed, but in 250 it was said, well, the causation analysis applies. And if we touch on the POA clause, as I've said I would, if we go to, well, actually first what we should do is deal with Mr. Keeley's argument about the NDDA clause in our contract. So you'll recall he made an argument that because there's an NDDA clause as well as a disease clause, and we can see that at I've got 554, but that's going to be the wrong page. Going back to our policy schedule, that is.
On 554.
554. So in our schedule at 554, that's core bundle 2. We have the denial of access non-damage extension. And our extension is at 557. That's the infectious diseases. On the non-damage clause, Opus could split the screen maybe, but you can flick if you're looking at paper. On the non-damage clause at 554, you have quite a short point. You have a clause that's triggered by any emergency arising which is likely to endanger life or property, and then you have the exclusion, and you have a smaller limit at 7.5 million. And Mr. Keeley says in paragraph 82 to 4, and he said it again today, the NDDA clause covers public authority closures responding to events outside the premises, but excludes disease. And this shows that the infectious disease can't be intended to provide similar cover. And we say that that's wrong. Before we look at the... well,
I don't think he went quite that far this morning.
he said, I think, that where you've covered it in one place, that shows the distinction between the other clause, which is doing something different because it's at the premises.
But he didn't.
Yeah,
he
I think
didn't
you're right.
say
Yeah, it's not exclusion.
that it's exclusionary.
Correct.
He accepted, I think, very fairly in principle that it might be covered by the other clause.
He did accept that there's an exclusion, which is why. The same argument was made. I don't know if you can just leave the policy there and just open up minor typing, which is 64. Page 1531. Or authorities, not D. Authorities 64 1531. So we see the argument there was in reverse. But at paragraph 9, the clauses, and you've got a disease, you've got an at the premises denial of that. You've got your disease clause at the bottom of 1532, which is notifiable human infectious or contagious disease excluding AIDS at the premises, and that has a closed list of diseases, because if you turn over the page you'll see an endorsement that lists what they are. If that couldn't be available, and they were claiming under the NDDA clause, which was in extension 1. B. Sorry, C, not B. The actions or advice of the police or other competent local authority due to an emergency threatening life in the vicinity. That was the cover that was relied upon in China Taiping. It failed because of the local authority provision, other competent local authority. But in that, before he won on that, Mr. Keeley argued that you couldn't get disease within that clause because you already had a disease clause that shows what Parliament intends to do with disease, and that's below 2. And it would be very odd, and he uses surprise, I think is the word he uses in articles now, for the parties to cover disease explicitly with a closed list, but then have a generalised clause that covers disease. Disease is not on that list, just by virtue of them being an emergency. And if we go forward to paragraph 21, you see, you skim that paragraph, you'll see the argument. And you'll see the reasoning concludes at paragraph 27. And he says towards the end, the existence of potential overlap does not mean that any particular provision in one must apply to the exclusion of any other. Then at 28, they must be allowed to operate according to their respective terms, whether they contain elements which potentially overlap or not. So, whether Mr. Keeley goes so far as an exclusion or not, the same point applies. The clauses have been selected in the extensions, and they may overlap and they may not, and they cover what they cover. And although Mr. Keeley cited Lord Mance on a different point several times, this point Keeley is right also, and we'll see it from our clause. In some ways, it's actually harder for Mr. Keeley here, because here we have an actual infectious disease clause, which just does whatever the parties want to do on disease, whereas there, the argument is that the NDDA clause was somehow limited by the more specific clause, which one can at least see the superficial attraction of, because it's a more specific clause. But more general.
I think you're fighting the last war. I mean, Mr. Keeley fought those, and he's got a different point now.
Slightly different, my lord, slightly different. The general point of you must read the clauses as they are and let them do. Still applies, and we can see that if we look at the clauses. The disease clause, we can do kind of typing. The disease clause has a high limit. It has a narrower trigger in the sense that there must be closure, but not triggering or some of the NDDA exclusions, so it doesn't have the 24-hour minimum. It doesn't have the exclusion where you have notice from the public authority. It covers some things that may not be an emergency, like to endanger life, so it covers vermin, etc. Vermin and effective sanitation may not endanger life. Even some of the notifiable diseases may not endanger life. Food poisoning, polio, etc. It really doesn't. The simple fact is the parties wanted to deal with infectious diseases through a different provision, as is common, and they did so. You can also see in the NDDA clause, it excludes at point 3 consequences of physical damage, which is then covered by the denial of access damage extension immediately above, which has no 3-month limit and a higher financial limit. And it excludes electricity.
Well, it might be said that commercially it just provides an avoidance of two of the same peril being covered by 2 different clauses.
Exactly. The parties wanted to avoid overlap. They don't always. Sometimes they leave the overlap. But here they wanted to avoid it. So they said, we've got a specific disease clause, and that's going to deal with disease. So I'm going to exclude disease, just as I've got a specific denial of access physical damage clause. So I don't want that overlapping with my denial of access non-damage clause. So I'm just going to exclude them. And they have their own life. And just because the wording is different, one of them's about endangering life and it goes to immediate vicinity, and one of them's about at the premises, doesn't of itself prove anything at all about the causation test that the parties intended to apply. You have to rather assume that an at the premises clause has a narrower causational test in order to conclude that that's a distinction, because unless that's the result, then all you have is 2 separate clauses with different territories covered for different things. So that's the textual. I think I will briefly go through Corbyn and King, but perhaps tomorrow is the time for that, given the time.
Yes.